51 of 20, ওর মধ্যে ক্যাপটা দেখে না, ক্যান 1 of 20 আছে কিনা, কিংবা ওল্ড নাম্বার হচ্ছে 455 of 20
456 of 20
আর 455 ও আছে। আছে দেখবে সেকেন্ড জাজেস কপি আছে কিনা, ক্যান 1 আর ক্যান 2 আছে কিনা দেখো।
second copy
Rosh's leave to mention a Group 6 matter. Now, this has got some urgency. The husband of the petitioner concerned, who's before the court, has been succumbed to death while he's on duty, being put on fire. Now, this person before the court is not getting his terminal dues, nothing. And Lordship knows, my lord, when misfortune comes, not in spies but in battalions. She herself is a cancer stage 4 patient.
So what is the, just a minute, Group 6 is on which day? Keep it on Tuesday.
Tuesday. To be mentioned. Great.
Please inform whoever is appearing. Please. Do mention.
Lordships, may be permitted to mention one matter. Lordship, this matter I have mentioned yesterday, and there was fallen from Lordships that this matter is not the determination of this court. Lordship, this is WPST, not CT. There was a typographical error in the order, Lordship. Lordship, the minor son, the matter relates to the family pension of the second wife.
See, you mention on the day on which WPST is taken up. Have a look at the list. On the day on which WST is assigned, on that day you mention.
Milord, I'm praying for leave to file this appeal without the certified copy, Milord. Day before, it's a Group 6 matter, Milord. Day before yesterday, order has been passed, and on that date, Milord, I have applied for the certified copy. Milord, kindly grant me leave to.
So why can't you wait a few days?
No, Milord, it will take some time.
So
Milord, by the order impugned, Milord, my interim order has been vacated, Milord. I have received a threat at Guwahati, Milord, a live threat, Milord. It's difficult for me. I was protected by this honorable court, Milord. There was an order of Honorable Acting Chief Justice, order of the division bench, Milord. Following that, Milord, twice, Milord, interim order has been passed. initial was passed, then my lord, it was extended. Day before yesterday, my lord, it was vacated.
So now the issue has finally been decided.
Writ petition is pending, my lord. I am in connection with the interim order only, my lord.
All right,
Kindly,
file it, give an undertaking for supplying the certified copy.
my lord, I shall. I'm giving it.
One thing I was just beseeching, Lordship has posted on Tuesday. Instead of Tuesday, kindly make it Wednesday.
Next Monday,
Next. Okay.
next Monday, Monday week, yes.
What number is there?
Number 12.
But that was not a great literally on 20 being by 24 seconds of months. And what is not a subsisting matter of months. Only on that for the purpose of extension of the intake.
So it is on list today.
Just not a great literally on Monday.
So you said number 12.
Put number 12.
Oh, quote number 12.
So activities put number 12 is not a matter of not doing it on Monday. And intake orders is not a subsisting.
24th is the last day of the interim order. The interim order is to lapse on 24th. 24th to be mentioned. 24th to be mentioned. Please inform. Yes.
Lordship, Lordship, may I be permitted to mention another matter? This is Lordship Group 6 matter. We have succeeded in the writ petitions, Lordship. Now the state has preferred the appeal. The appeal was heard by Honorable
You cannot mention the state's appeal. It is for the state to mention its appeal. Yes, call the
because
list.
they will never come up.
Call the list. Call the
Yes,
list.
Item number 4.
I am for the applicant.
Yes.
May I just indicate one thing? One of this writ petition was taken up by your lordship on 4th August 2025. Now, on that date, my lord, the petitioner, my lord, appeared in person, my lord, because his erstwhile advocate on record, my lord, he left the profession. And thereafter, my lord, your lordship was pleased to grant leave, my lord, to engage any advocate on record. My friend is appearing, my lord. He filed his wakalatnama.
Already filed.
The petitioner before your lordship,
When you have filed the wakalatnama?
when you file, followed on 16th June 2025, 8th August.
Is it there? Just see if the wakalatnama is there. If it is not there, we'll have to get it tagged there. Just let them check. No, he's saying he must have filed. See if
On
it is
the
there.
last column, Vakalatnama file, last column of that page, at the end of
Yes.
8th August, my lord.
Mr. Anjan Sen Gupta.
My lord, my friend, he is my lord.
What to do? Maybe less matters. There. No, that is not. There is any other wakalatnama? Yes, sir. Take down. The letter. It arises out of West Bengal Tribunal order.
West Bengal State Administrative Tribunal, my lord.
Yes. Yes, please proceed.
My lord, the petitioner, my lord, was a block medical officer, my lord. He's a doctor, my lord, under the West Bengal Health Services. Now, my lord, sometime in 2002, my lord, a show cause notice was issued, my lord, alleging that, my lord, he has practiced, my lord, beyond his official duties, which at the relevant point of time was not permissible. Now, my lord, he submitted his reply to the show cause. Now, my lord, matter ended there. Then, after a lapse of 6 years, my lord, in 2008, my lord, a charge sheet was issued on the same ground, and my lord, another ground that, my lord, he issued a rent receipt in favor of his wife to enable her to get a pharmacy license. These are the two charges. One is, my lord, that practice beyond official duty. Second is, my lord, issuing a rent receipt.
Rent receipt for his official accommodation.
No, my lord, rent receipt, my lord, that has not been disclosed.
Then otherwise, how it will constitute a charge?
My lord, that is one thing. We filed an original application before the West Bengal Administrative Tribunal, my lord, saying that there is an inordinate delay because all these incidents are of 2001 and 2. You, my lord, issued this charge sheet after a lapse of 6 years. Therefore, there is an inordinate delay in initiating the disciplinary proceeding. Now, the tribunal, my lord, passed a direction for filing affidavits without, my lord, passing any interim order. Challenging that order, my lord, we filed this writ petition. This was taken up by this honorable court.
It's a writ of 2010.
Yes, 2010, staying the my lord, continuation of the disciplinary proceeding. Now, this matter is pending since then, and the tribunal, my lord, now there is a direction to file affidavits, my lord. No affidavit has been filed by the state, neither before the tribunal nor, my lord, before your lordship. Now, the tribunal is not functioning as on date. Although, my lord, the tribunal is the court of first instance, the issue ought to have been decided by the tribunal in view of L. Chandrakumar's case. But today, my lord, your lordship knows administrative tribunal is not functioning.
Let us see the charge memo.
Yes, ma'am. The charge sheet is at page 97. My lord, kindly, my lord, this is dated 22nd of February 2008 at page 97. This is a typed copy at 99A.
And what is the date of the interim order passed by this court?
My lord, the interim order was passed on 22nd of December 2010, my lord. Page 99A, it starts from page 97. May I please page 9?
Just give us a minute, please. Where is Mr. Sen? Mr. Sen is appearing. You are appearing. Oh, you are also with him. Yes. What do you have to say? So this is against the interim order only.
Against the interim order. My lord, if the tribunal would have, my lord, there is no member, my lord. That is why I will face
So
difficulty.
you are not prejudiced. You have a stay. There is no member. There is no member.
That is true, my lord, but it's pending for a long time. And today, my lord, your lordship decide this, my lord, on the basis of this issue is no more res integra, my lord. The Supreme Court, my lord,
The
decided.
issue is what is before us. Before us is an order challenging the grant of refusal to grant an interim order.
That is finally not been decided by the tribunal. And the difficulty is no affidavit has been filed, my lord, explaining the delay, neither before the tribunal nor before this court. Therefore, that is another aspect. My lord, they could have, my lord, placed before your lordship the contemporaneous documents. That what prevented them, because initially in 2002, my lord, they issued a show cause notice on the same charge.
Where is that show cause?
That show cause notice is at page 90. 90.
90.
90, my lord. The type copy is at 90 capital A. Exactly, I'm sorry.
And this was only regarding the practicing,
Practicing charge
not
one.
regarding the forced rent receipt.
With this charge 2.
No, forced rent receipt was also an issue there, or forced rent receipt.
Initially, it was not. The charge 1, that is the practicing aspect, my lord, that was pointed out in 2001. 2002, I'm sorry.
No, but there is a written statement dealing with
Well, page 91 is my reply or written statement, whatever, my lord.
But in that you deal with both the charges. Because this show cause is not legible.
Focus 90A, my lord, is a typed copy.
Yes, there is a type copy. It has been written. Just see your reply at 91A.
Yes. Lord, 96, my lord, I will, my lord, request your lordship to kindly come to page 96.
So where is your reply to this show cause of 5/7/2000?
96, my lord.
So regarding the second charge, there was no show cause. But why you have sent a reply regarding the second charge? Why have you sent a reply touching upon the second charge in 2002 itself?
That I do not know.
Please read paragraph page 92A.
Yes.
92. It starts from 91.
But this was not part of the show cause notice, but my lord, during the well, your lordship will find 91A onwards, there are some.
What is this? This is a statement recorded somewhere. Written.
Yes. These are all statements, my lord.
In what context this statement has been recorded? There is a missing link somewhere.
Yes.
Either this has to be in response to some show cause sent, or a statement has been recorded somewhere.
These statements were recorded, my lord, prior to this, between, my lord, the show cause notice and this statement of defense, my lord.
No, it doesn't appear so, because this is of July 2007. It is rather after the show cause. The show cause is of 5/7.
Yes, July 2007.
And these statements are of 11/7, see page 95.
My lord, this was, my lord, next second. No, eight statement. Right.
Response to your queries. Response to your queries, which is noticed.
Page 91.
So, my lord, this was, my lord, your lordship will find 91 capital A. Your lordship will find that these statements were made on in 2003. Kindly see, my lord, at the top of that page. 91.
Therefore, we are saying it is not prior to the show cause.
Right.
Now, the another date you will find is of 2002, 11/7/2002.
11/7/2000.
One statement is of 11/7, page 95. Just few days after the show cause. So what was going on? Why these statements are being recorded? Documents seized, witnessed. There was something that being done by the vigilance department also. There is any other proceeding pending against you?
No. Proceeding pending, I think.
At the bottom of page 95, you see it says Inspector in charge, Anti-Corruption Department, Vigilance Commission. So were they waiting for the proceeding there to be finalized? Because you have annexed these documents. What have you stated about these annexures in your writ petition? Let us see.
The certificate copy টা দেখুন। এইটা আমি hide করতে দেখুন।
So what is this vigilance inspector? This is arising out of a criminal case, or
No, madam, there was no criminal case.
then who is this vigilance inspector? It's under which setup? What is the organization? I'm trying to
It
understand.
arose, my lord, I shall take instruction, my lord. It arose, my lord, there was some vigilance, I mean allegation before the vigilance. Then, my lord, there was a preliminary inquiry. Thereafter, my lord, the show cause notice was
So
issued.
this is vigilance means what? It is a criminal prosecution.
No, not always, my lord, not always.
So at least speaking for myself, I don't know
Page 39 onwards,
this authority, this vigilance inspector is under which organization?
my lord,
Under the police organization, there is a criminal prosecution wing, or it is part of the state government?
And instruction for stating all the facts. Now, if you not take kindly, mother, go through it. Then, mother, I think, mother, something to repeat on this. Say kindly.
Why have you not filed affidavit if you have an instruction? Place it on record, then we'll consider.
The very
We don't want to see your instruction. That is your privileged document.
That can be reflected in my affidavit.
We don't know.
I do not-
You may file all, you may not file all. That is your prerogative.
I am not saying this is my privilege. This is the facts, my lord. That is, my lord.
I am averse to looking into your instructions. Speaking for myself, I know here in every case you hand it, but I don't think it is proper. When you discuss the matter, we don't know what. Yes. What do they say?
Me, I think. My lord, it appears that my lord, the petitioner being a doctor in the health department.
See, what we have seen right now is that he was on leave, he was undergoing medical treatment. During that period, there is some allegation that he has been imparting or giving treatment by taking fee.
Running his, my lord, the private chamber.
No, that's not the allegation. The allegation is in the charge memo that you have taken fee for giving treatment. That is all.
Private, in a separate private chamber.
There appears that only one incident is reported. It's not a continuous thing. They say that some receipt has been discovered that you have taken money for treating some patient, and that patient has been named as a witness, as we have seen. There's only one incident. After that, we see that some vigilance inspector has come.
Yes.
They have gone to his place. They found a nursing home. They have taken some registers. In the register, there is a receipt of amount, which now is perhaps going to be used as evidence against him. He has responded that during the investigation team, when it has come, it has taken all the documents. That is for a nursing home which was running there. I have nothing to do with. That is his response. He says, I was undergoing treatment. I don't know. There is no question of giving any kind of treatment. But then after that, what did you do for 6 years?
I think, after instruction, I think, because the matter is pending. Yes, he has challenged and then the tribunal and then the High Court. The High Court, the matter is pending.
No, in 2002, all of this happened. In June, July 2002,
Right.
all of this happened. A charge memo you have issued in 2008. So we are asking you, what did you do for 6 years?
So for my instruction here also that the final order of the departmental inquiry is not available at present.
How it can be? There is a stay.
So
It cannot be that is nothing.
I can take instruction on this.
The only issue on which he has got an interim order is that there is 2 charges in the charge memo. One is in relation to 2001, that he has given a forced rent receipt to his wife to enable her to carry on the business of some medicine pharmacy. The other is that in 2002, there is some material has come to the knowledge of the authorities that he has taken fee from someone for giving treatment. Both of these are in relation to 2001 and 2002. Charge memo has been issued in 2008. So that is the only issue you are required to say. Why after 6 years? Is it a stale charge? Is it not a stale charge? That is the issue. It has not proceeded on merits anywhere. At that stage only it has been stayed by the High Court on the ground, on prima facie finding a ground that it is a belated charge. So therefore it has been stayed. Now, and at this level also it is getting delayed.
2008, it appears that the vigilance started and then the inquiry proceeding and then the.
Where is the starting by the vigilance in 2000?
It appears that on 22nd of February 2008, a departmental inquiry was initiated and report that, my lord, the vigilance branch, my lord, report. So, my lord,
Vigilance branch report.
So, my lord, I have to go through again my other documents.
What is the setup? Please enlighten me. What is the setup? Why? What is this vigilance department? Charge memo is issued by the disciplinary authority. And vigilance department, what is this vigilance department?
I think that was preceded. The charge memo is my lord.
What is the status of the vigilance department? It is part of criminal investigation or it is an internal departmental mechanism that we are trying?
As it appears, not as a criminal, because
Under which provision?
my lord,
Because see, departmental action has already been initiated. There cannot be 2 departmental actions.
no, on the basis of the report of the vigilance, the
Vigilance, what is this vigilance?
vigilance, my lord, in every, my lord, I think, my lord, the State Department, my lord, if it appears
that the vigilance is required.
There is, that is not rare. That is there in almost all states. State Vigilance Department is there. But any action of the State Vigilance Department usually culminates in initiation of a criminal proceeding, which is registered in a police station. And a criminal trial follows. A vigilance case is normally conducted in a criminal court. But here, I'm not clear whether this is a criminal prosecution or.
May I come back with an affidavit?
If it is a criminal prosecution, then we don't know, you may be in a position to explain the delay. Mr. Mukherjee, what is this vigilance? Vigilance inspector? You have any idea?
এটা হচ্ছে তোমার
You also don't, you are also.
Yes, I tell your lordship, this is a body, my lord, constituted by the state. My lord, it continues a proceeding parallelly, my lord, with the disciplinary proceeding.
How
My lord,
can
to
it be?
find out, my lord, there is any financial irregularity or not.
ব্লক মেডিকেল
Block medical officer of health. Under the director of health.
ভিজিলেন্সের কাজ কি তারা কিভাবে করে, তাদের কি অথরিটি পাওয়ার?
That's the vigilance manual.
Vigilance manual. So it gives rise to a criminal proceeding.
Sometimes department proceeding, sometimes civil.
as per the opinion.
So this is only for investigation.
If some.
So it is in aid of the departmental proceeding.
Department proceeding.
Then again inquiry proceeding which start
After
as
vigilance commission report, it will go to the department if there is a private.
Vigilance manual, can you give the name of the,
I will hand over.
please supply it today, any one of you, please. All right, so at least we will have a look at the setup. I'm not aware of the setup, so I would like to see.
Vigilance manual is there.
Yes, a very small issue. Whenever you are asking, we are giving 3 weeks, but in these old matters, please try to expedite so that it is done in 2 weeks.
So, my lord, the all other, the connecting applications, all will, appear on the next day along with this.
There are applications also.
There are three or four applications. One is for application seeking. Application আছে না? One is for application seeking leave to file further, the Bhokalotnama.
That is already, that is done.
Another is application for, the delay in condonation of delay in filing the restoration application. It was
Restoration is already allowed.
That was allowed and ultimately, my lord, this first order I have.
After that, you are appearing. After restoration, you are appearing. But why the CAN applications are appearing today?
my brief, after this, that is why. After that, the brief allowed. Very good. Okay.
CAN 2 is for what?
Can 1 and 2 has not been served. So I do not know. Can 3 is restoration.
CAN 2 is for condonation of delay. That must have been allowed. Why it is appearing? And CAN 3?
Can 3 is for restoration
Oh,
application.
both have already been disposed of. Why they are appearing? He bothers to check the order sheet, nothing. Everything the court has to do. You don't even bother to go through the order sheet. Just see. Here, every day this is.
অর্ডার হয়ে গেছে অর্ডারটা তো করিয়ে ডিসপোজ অফ করতে হবে
Application for CAN 3.
সব করে দিচ্ছে ওটা অরিজিনালি বলুন ও কি করে জানবে
CAN 4 stands allowed. CAN 4 is for filing whatever.
ওগুলোকে তো
And 2,
And 2 and 3 both, my lord, order is not fast.
can choose for what আমাদের সাপ নেই এখানে
then which CAN has been allowed? CAN 4 only.
CAN 4.
What
filing
CAN
and color. Yes.
For filing, but that is only one which is cancelled. 2 and 3 has not been allowed. So how much delay in filing the restoration?
almost more than 1 year but I am not
জজ সাহেবকে বললে ভালো হতো যে
Why do you file condonation in writ proceeding?
Limitation does not act
and
upon.
dismiss
Section 5 application. Both allowed. If 2 dismiss, 3 allowed.
Dismiss 3 allowed.
my lord, there are only one, my lords.
Item number 5 and 6.
5 and 6, I'm praying for anything of the matter.
Sorry, give the file.
Kamlesh Jha is leading me in this matter.
Huh?
Mr. Kamlesh Jha is leading me in this matter, my lord.
You start, let us see what it is. Oh, these are 24 matters. This is not old matter. Why do you want time?
Personal difficulties, my lord, could not come, my lord. Kindly takes up the matter after 1st of December, my lord. Last chance, my lord.
No, you please proceed. This is the third time.
Chance, my lord.
Where is the answer to the order? You must be knowing the order 1725. What do you have to say? The delaying will not help you. There is a query put by the court. By taking 3 adjournments, you think you will succeed. You have to argue the case. You can't evade the court like this. This is not expected. Once we ask you a query, you will take 3 adjournments. By way of last indulgence, matter
আপনার নামটা জি
Item number 7.
I appear for the petitioners.
but you can here also 6
For the petition, I'm led by Mr. Basu Millard.
this bench will go.
For the petition, I'm led by Mr. Basu. He's appearing Millard virtually.
yes, yes.
Yes, madam. I'm sorry, madam. Milord, in item number 4, your lordships were asking, Milord, regarding the Vigilance Commission. Sorry for this unsolicited interference, Milord. Your lordship may kindly note that the government had taken a resolution by a memo dated 2021 GSE 4th March 1965. As a sequel thereto, Milord, this Vigilance Commission, it is not an act of legislature. So, Milord, the resolution is possibly is absent because your lordships were asking this query to the government.
Yes. So this is internal vigilance or it is a criminal prosecution?
No, it says me that it was established me that through a government resolution, making it an executive body rather than a statutory. The scope is to broad all state government department under the commission's ambit and to curb corruption, to prevent corruptions. It has two aspects, my lord. Any irregularity which might lead to the path of corruption has a criminal nature. This can be done, and it cuts both ways. But it is not essentially always leads to the path of a criminal prosecution also, my lord. But be that as it may, my lord, it is not an act of legislation. 221 a GSE March 465, the government had taken a
Can you
resolution.
please ask someone, your junior, to give us the details so we can?
I will go reach Port Millard by 1:30 and I will give a note.
Nice.
But you
of
will
you.
lordship take, not take, but do not believe me, Millard, blindly, because this is also, Millard, I have taken a note when I used to appear for the state, Millard. But I have found out certain notes, Millard, but it might lend meaningful assistance.
Yes,
Because it is
thank
not
you.
an act of legislation. And now,
Yeah.
Millard, today, this case, Millard, the one Gokul Chandra Dey, Millard, the predecessor in interest, Millard, he died on 19th February 2016, leaving behind his wife, son, and one married daughter. Today, after his death, Millard, he was a Group D staff of a PWD department, Millard, and he applied before the department, Millard, as a candidate, Millard, for being appointed under the compassionate category on 21st March 2016. Now, Millard, thereafter, what happened? No response was
A
coming.
reply was filed before the tribunal by the state.
Mr. Chatterjee.
No reply filed before the tribunal.
Was
No.
any reply filed before the state, before the tribunal?
Only the Millard, there was a leave to add some respondents party and they have been added.
Nothing. Milord, on February 2017, after 1 year, Milord, the deceased wife write an application for the second time to the Joint Secretary, which is at page 15, Milord, requesting the authority to give the benefit of the Provident Fund gratuity and accidental benefit, and also request
No,
to
Mr.
give a
Basu,
block
the
towards.
first thing is if they have not been given an opportunity before the tribunal, then we would like to give them an opportunity. That's why we are asking you whether a reply was filed before the tribunal. It has been disposed of on the first day.
Milord, this was the order, Milord, if your lordship, Sharanya Chatterjee is requested to,
Yeah.
because my there is a network issue, I am not
Perhaps
able to. This is, Milord, the order, if your lordship kindly takes pain, 2nd February 2024. The matter is taken up by the single bench pursuant to the earlier notification. The applicant has paid for, then, Milord, only the submission recorded. Uh, uh, no, Milord, admitted fact. They have they possibly it appears, Milord, no
Yes,
reply was.
if you see the second
Yes,
last paragraph,
yes,
the tribunal says
yes,
from the submission of the learned counsel.
yes. Your lordship's apprehension were absolutely
So
right,
they
Milord.
let them file an opposition, then we will consider.
Yes, Milord.
Yes.
This is the very second order. So
And Milord, your lordship kindly takes note. Your lordships were uh, kind enough to direct, Milord, the second wife of
They
the
are
deceased
appearing now.
person.
They are
Yes,
already
yes,
appearing.
yes.
So they will be
There
at
is.
liberty also to file an
Milord,
opposition.
Milord, it appears there is no discord and note, Milord, between the parties in the proceeding, accepting the statement.
Very well. You may not avail the liberty. Yes. Heard the learned advocate representing the
deeply okay.
19th December. Item number 8.
Number 8, my lord, I am for the petition. I am late. Callal Basu.
yes.
Milord, in this matter, on the last occasion, Mr. Boshu Malik, who used to appear for the state, Milord, he was unwell, indisposed of, and that is why he could not reach the state, Milord. He accordingly paid for time. And without the
Now
state
he is not
presence,
appearing.
he is not appearing. On that occasion, Milord, he appeared on virtual mode. Now he happily disappeared.
How to proceed with these matters? That is the issue. Now there is a change. Obviously, there will be a change in council, and pursuant to the earlier order, has affidavit in opposition been filed.
Yes, my lord. Affidavits have been exchanged. So, my lord, may I serve an
Yes.
government pleader, my
You will have to, because somebody has to appear. Otherwise, since you know that he is not to appear anymore, it is best that you serve a copy.
Yes,
We we are
absolutely.
informed that
Item number 9.
Mr. Shobhan Banerjee is appearing for the state in this matter, my lord. I'm paying for a short passover. He's on his way, my lord.
Let him come. Which matter? What is the prayer in the OA? Let us see.
But page 75 of your lordship's brief.
Where is the advertisement?
That page 37, my lord.
Page 37.
My lord.
What is the date?
My lord, 12/9/2019, my lord.
This one, 9790. Right. Was already. He objected.
He made the okay. The objection was not made. Participated in the objection.
Raised objection and participated. Both he has done. So the objection so participated. He participated. Challenge advertisement. He wants some kind of now. You didn't challenge the advertisement.
My lord. Yes, my lord.
You challenge the advertisement.
Yes, my lord.
When?
Prayer A, my lord.
No, no. While the process was going on, you did not challenge.
I raised protest to the effect that, my lord, WS may kindly be also included, my lord.
Yes, so you were knowing that there was a
knowing.
deficiency, but you did not
Yeah.
challenge. Where is the prayer again? Which page?
My lord, 75. Sir.
75. No, this is selection process completed.
Yes.
It's not during pendency.
No, I came after the declaration of the result.
Not only after 3 months after. How this can be looked into? How it can be looked into? Tell us. There is an advertisement of September 19. You say that in July 19, the state government in principle has accepted that EWS reservation has to be given. It's a different thing. They are saying that modalities had to be worked out, plus the requisition was sent prior to the adoption of EWS. That is a different, that's on merit. Thing is that when you saw the advertisement, you told the respondents that why EWC reservation provision is not there. Still you participated. You did not challenge the advertisement. You participated as general category. The result declared. Thereafter, after 3 months, you say that everything should be checked. Is this permissible? Can this be done? That is the only issue.
Lordship recollects, my lord, this was the issue that Lordship asked me Lordship helped me with a judgment and asked me to give precedent, my lord, to buttress my stand, my lord. In that effect, my lord, I relied on a division bench judgment of this honorable court, my lord.
This court?
Of this honorable
Which judgment?
I handed up that judgment in the last occasion, my lord. Lordship directed me, my lord, to hand over a copy. On that occasion, my lord, I handed up a copy also, my lord, and gave the citation, my lord. If you kindly have, I just give the citation once again, my lord.
19 SCC online 9250.
My lord. Paragraph 24 would be, my lord. Relevant paragraph 3, my lord. 2 subject to correction, my lord, is the facts of the case, my lord. Soft copy 3, my lord. No, soft copy. Judgment at
No, see paragraph 3. Immediately after there was no response by the chairman, they had moved the tribunal.
yes, my lord. That is in factually, my lord, distinguishable. But paragraph 24 also takes into account, my lord, had they not come at that point of time, what would have been the effect, my lord?
Paragraph
24, my lord. 2019.
Yes, so there is no distinction, because you see in para 24 also, we have said that the coordinate bench has said ultimately what has been held in paragraph 24, you see.
May I place it?
Yes, you may.
I will be placing, my lord. 1, 2, 3.
You are saying even if the tribunal was moved after declaration of result,
Yes.
you are reading that.
Yes, yes, my lord.
But the paragraph does not stop there.
My lord, kindly
The
say.
paragraph goes down. The state, in terms of the law enacted, protection of interests of the backward class is mandated not to fill up reserved category by general candidate. Even though the flaw in notice inviting application right from the day the same was brought in public domain, and they had participated in the process without raising demur, could it be said that they had waived their right to challenge the notice,
Yes, my lord.
not the result after conclusion?
After challenge the notice after the result, my lord.
Cannot.
My lord, because my lord,
That we cannot read into this.
my lord,
That
even
would be stretching it a bit too far.
very well, my lord. Then I will really relying on a different set of judgments of the Honorable Apex Court to that.
Yes.
My lord, the first judgment, my lord. My lord, lordship was very correct when your lordship has held, my lord, observed rather, my lord. When your lordship has observed, my lord, that ordinarily, my lord, if a person participate in a selection process, my lord, then, my lord, by the virtue of his participation, my lord, one is precluded from challenging the selection process, my lord. My lord, though it is the law ordinarily, my lord, laid down by the Honorable Apex Court, my lord. However, my lord, there is an exception. There are exceptions to this general rule, my lord, which will be evident, my lord. Paragraph 20 of a judgment reported in 2007, 8 SCC 100, my lord. I will just place it and hand over the judgment, my lord. We are.
Where is the judge?
2-line paragraph, my lord. Sir, আমার কাছে সমস্ত judgment protected. My lord, may I just place it, my lord? I'm not getting the judgment, my lord.
No. How will we consider? Unless you give it, how can we consider? You have the copy.
My lord, I have a soft copy, my lord.
No. Give us 2 copies. That's not the way you. This is the only issue you have to argue. Why you have not come with a judge?
I have, my lord, that is covered on a different judgment, my lord. I'm coming serially, my lord. One judgment will cover those judgment also.
So give that judgment. You don't have to cite all the judgments which are considered in the later judgment.
In 2015. Yes. I don't have that judgment, my lord. Kindly consider one judgment, my lord. This is 1991 SCC 305, my lord. Paragraph 12, I will be relying upon, my lord, for the proposition, my lord, that if there is a malafide in the selection process, my lord, then it can be challenged, my lord, even though I have participated in the selection process.
Paragraph?
Paragraph 12, my lord.
All right. Any other judgment?
Yes, my lord. I will be relying on other judgments, my lord. 1 SCC 305, page para 12. 305 is the page, para 12. 638.
Yes, all right. This we will consider para 12. What else?
My lord, the another judgment that I was referring to, my lord, is 2007 8 SCC 100, my lord. I do not find a copy with me, my lord. I just read out, my lord. Kindly permit me
This
to
is
read
the
out.
way to cite a judgment.
Not the way.
Unique. You will read and we are not required to see. What are you doing? Why should you come like this when you know this is the point you have to address? If it is referred in a later judgment, give the later judgment. Why are you not giving the later judgment?
No, my lord. This is the judgment of, my lord, 2007, and I'm carrying the judgment that your lordship has referred, my lord, in 2020 judgment, my lord, which is of, my lord, Anupal Singh, my lord. That I'm carrying, my lord. But the point that your lordship wants me to address, my lord, that is there in that judgment.
And you are not having the judgment. You say you will read and therefore we should understand everything.
Absolutely not, my lord. It is
What
completely
a
on me.
wonderful way of presenting a case.
It's all completely on me, my lord.
Why? Second time. For one small point, we should keep giving you indulgence after indulgence. There has to be a limit to this. Last day we had told you that you come with the judgments. Same case has to be taken up every day for the same thing. What is the citation? 2007 volume 8 SCC?
My lord, 2007 volume 8 SCC page 100, my lord.
Page 100.
Yes, my lord. Para 20, my lord.
You give it on a piece of paper. Which other judgment? Proceed to the next, whichever judgment you have to give us. Otherwise, this is the only judgment now.
No, my lord. If your lordship sees the judgment that I have placed before your lordship, my lord, that judgment in turn has relied on a series of Supreme Court judgments, my lord. From that judgments I am quoting, my lord, which your lordship will also find in the judgment that I just handed up, my lord. The coordinate bench judgment of this honorable court, my lord. On three judgment judgments of the honorable apex court reported in 1986, my lord, supplementary SCC 285, which is the Om Prakash Shukla case, my lord, which lays down, my lord, three judge bench judgment, my lord, of the honorable apex court, my lord.
In which paragraph?
My lord, para 24, my lord.
24 you have already placed.
24 of that judgment, my lord, of the three judge bench judgment of that honorable apex court, my lord. Supplementary 285. I shall make a compilation when I hand it.
What is this? You can make for every day. We will keep adjourning it.
I will come up with a compilation method.
Where is it considered in this judgment? In which paragraph?
That judgment method.
Difficult for the court. Rather than assisting us, you are making it difficult for the court.
Yes, my lord.
Which paragraph? Tell us. Not a responsible way of appearing in a court. Very unfortunate. Yes, which paragraph?
My lord, paragraph 16, my lord. Page number, my lord, 6.
Paragraph 6.
Paragraph 16, my lord, page 6.
Of which judgments?
Of the judgment that I handed up, my lord, the honorable coordinate bench judgment, my lord.
Is that
page 6, my lord, paragraph 16.
paragraph 16?
Yes,
yes.
Kindly sees, my lord, which has considered this judgment, my lord, 1986 supplementary SCC 285 Om Prakash Shukla versus Akhilesh Kumar Shukla, my lord. My lord, kindly consider next page, my lord, sub paragraph 24, my lord. My lord, kindly consider, my lord, page 10 of that judgment, my lord, where it says, my lord, after paragraph D, my lord.
All right.
My
You
lord,
don't know.
the other judgment, my lord, I will take the compilation of all that judgment, my lord, is 2015-14 SCR 7.
Should not. Which part of paragraph 16 you are relying upon?
My lord, paragraph 16, I'm relying upon for the proposition, my lord, that ordinarily, if I participate, my lord, I will be precluded from challenging the selection process. But if there are some exception, one of the exception is that if I have raised a protest, my lord, then, my lord, that bar.
Where is that in paragraph 16?
My lord, kindly seize, my lord.
Paragraph 16, the apex court is taking note of the fact that in Om Prakash Shukla, the High Court set aside the result. Even though they had all participated, they raised an issue that it was held under a wrong rule. High Court squashed the result. Now what the apex court has said. Paragraph 24, read.
Yes, my lord. Moreover, this is a case where the petitioner in the writ petition should not have
Should
been
not have been granted.
any relief.
So
Kindly see, my lord, he has the reasoning that means follows that, my lord. He has appeared for the examination without protest. So, my lord, this is the basis on which he should not have been granted any relief, my lord, because he has chosen to waive his right, my lord. That's number one, my lord. Number two, my lord, in another judgment, your lordships, my lord.
not only that, read the line after that. You can't just read one line.
He filed the petition only after he has perhaps realized that he would not succeed in the
Correct. Which exactly applies to your case.
Absolutely, my lord. Had it been a case,
What helps you? Which other paragraph?
my lord, this is one, my lord. Like, kindly take the Rajkumar decision, my lord. Kindly takes which I was trying to place before your lordships, my lord. Page 10 after D, paragraph D, my lord, before E. It is therefore abundantly clear that there exists exception to the rule, which, however, were not spelled out.
Correct.
We shall attempt.
There is exception to every rule.
Right, my lord. No, now, my lord,
It
kindly
not be
see.
said. That is
Yes,
there is
my
an exception to every rule.
My lord, then, my lord, the exceptions are dealt with in this particular case, my lord. Kindly sees, my lord. In page, my lord, page 13, my lord, I, which talks of a judgment reported in 2015, 11 SCC 493, my lord. Pradeep Kumar Rai versus Dinesh Kumar Pandey, my lord. It was after the declaration of the interview that the litigation, which ultimately reached the Supreme Court, commenced, whereby unsuccessful candidate challenged the interview process on several grounds, my lord. My lordship. Yes, my lord. Now, my lord, kindly sees the last sentence before paragraph J. What your lordship has held, my lord. If may I place it, my lord?
Yes,
if
yes.
properly read and understood, the decision in Pradeep Kumar Rai Supra is an authority for the proposition that despite participating in an interview, but prior to publication of the final result, a challenge laid to the selection process on the ground of illegality cannot be held to be not maintainable.
Correct.
Right, my lord? So, my
Yes.
lord, if that be so, my lord, lordship would kindly visualize the situation in which the result was published. My lord, it was at a time when your lordships, in a suo motu proceeding, my lord, has restricted, my lord, all limitation periods, my lord. If your lordship sees the period when, my lord, the result was published, my lord, it was during the COVID wave, my lord. So, number one, my lord, there at that point of time, my lord, the streets were deserted.
There's no question of limitation applying here.
Yes, my lord.
There was a condonation in WPC 5 of 2020 or 21. 20. WPC 5 of 2020 by the apex court saying that limitation will not apply. Did not say that limitation does not apply to writ proceeding.
No, that is true, my lord. But
and when have you challenged it?
My lord, in the midst of that corona only, 3 months after that, my lord, at the first opportunity that I have got, because I don't live in Kolkata, my lord. I live in the Bakura, far off from here, my lord.
All right. Anything else?
My lord, that is one, my lord. Kindly sees, my lord. Now, whether, my lord, not granting of reservation, my lord, whether that can be a ground of illegality, my lord. In that respect, I was placing.
That's not the issue. We are not going there yet. We are on the issue whether you can maintain the application. That after that, the merits will come.
My lord. Then, my lord, kindly, my lord, allow me to place another judgment, my lord, which is 2015 14 SCR 76. I'll just tell your lordships, my lord.
Yes.
Allow me to just submit, my lord, first, and then I shall hand over. My lord, this is a judgment, my lord. Well, this has some relevance to your lordship's parents.
This is the very unfortunate way of addressing a court. After all, whether you are having less experience or more experience, you are a lawyer. You are addressing a division bench of the High Court. And you want us to follow whatever you are submitting without showing the judgment. You did it once, we said no, now again you are trying to do the same thing. Very unfortunate way of addressing the court. Very unfortunate.
I tender my apology, my lord.
Huh?
I tender my apology, my lord.
You should.
Yes, my lord. I am
Very sorry. Last day we had asked you to come prepared on this.
yes, my lord.
We have recorded his objection. Still, we have allowed you an indulgence.
Yes,
Today, in spite of that indulgence, you are making it more difficult for us.
my lord. May I come back, my lord?
What come back? One same case we should keep hearing every day.
Today itself, my lord. I'll just go, my lord. Like prepare come.
Go and get the judgment.
Yes, my lord. Kindly, my lord. I'll get all the judgments and come back, my lord.
Go and get the
My
print.
lord.
Not bad. We should not get irritated, but we are humans.
It's a junior Northeast. Or is assistant also.
Where is he? He will come. Young members of the bar, they should learn these things. Don't want to get irritated, but what can we do? It's very irritating. Last day we gave him indulgence that you come with judgments. So you must have seen the judgments he has cited.
No, I've not seen, but I've heard, Lord, your Lordship, he has referred. No copy has been given. However, Lord, but first of all, Lord, I'm taking the point that the private respondents whose appointments are sought to be cancelled, he has prayed for, but they are not here, Lord, your Lordship. But the court should hear them. Because
They have been impleaded.
Yes, they were party. They have made party 6 to 25.
25 people.
6 to 25. Respondent number 6 to 25. The number
There are 18, 19 selected persons.
cases. And not only that, Lord, my learned friend is harping upon his application that after Lord, entering in the selection process, he made a protest application. But if your Lordship kindly see the original application, he has annexed, but this annexure has not there.
Which document?
Application actually his only base is application of protest. He was given.
There is one letter which he has shown.
We have annexed in the writ petition here, but original application he has annexed without annexure. Though he has mentioned in the application annexure D.
No, but now he has given us a copy.
That's
So
right.
if there is a
Whether
variance.
that application was at all before the learned tribunal or not. Because this is a matter of consideration.
No, in the OA, he has not referred to any such application.
Referred, but not annexed. No annexure. Without annexure, not the writ petition. Our original application is attached here.
All
It's
annexed.
incomplete.
All annexed are there, my lord. Not a single document has been left out, my lord.
Yes, catch your breath.
You kindly see the original application.
All annexed.
Right, we'll hear it.
No, application.
You got the judgment, give the judgment.
There is no annexure. And all the 6 to 25, they're not represented before your Lordship.
All are parties, my lord. All have been served, my lord. My lord, the first judgment, 7,800. There are 20 I was referring to, my lord. Fifteen 11 493 though.
Yes.
My lord, this is my lord Raj Kumar, my lord, and others 97-9, 5 to 7, my lord, paragraph 16, my lord.
What is the difference between these two
My lord,
judgments?
this says, my lord, that the principle of estoppel will not apply, my lord, if there is glaring illegalities in the selection process, my lord.
So you have given why to repeat so many judgments on the same issue? Why do you want to give 3 judgments on the same issue?
My lord.
That you have already given.
My lord. The next, my lord,
So one you have said that it is always subject to an exception. The other you are saying that if there is a gross irregularity or illegality in the selection process.
third, my lord, I'm submitting before your lordship, my lord, that if there is a violation of fundamental right, my lord, then, my lord, the principle of waiver will not be applicable, as your lordship has held, my lord, in the judgment that I have referred to, my lord.
Which judgment?
My lord, your lordship's judgment, my lord. My lord, kindly see, my lord. Paragraph 24, I may read, my lord.
Oh, the coordinate bench.
My lord, I'm placing, my lord. However, there cannot be any dispute that the right to reservation in public employment flows from Article 16 of the Constitution of India. The state, in terms of the law enacted for protection of the interest of the backward classes, is mandated not to fill up a reserve vacancy by a general candidate, even though the petitioner might have had knowledge of what they question mark perceived to be a flaw in the notice inviting applications right from the day the same was brought to the public domain, and they had participated in the process without raising demur. Could it be said that they had waived their right to challenge the notice? Can there be a waiver of a fundamental right? The answer to these questions cannot possibly be in the affirmative, my lord. So I was referring to this. And yes, lordship was correct, my lord. That Suomoto case, my lord, is, my lord, 5. I'm just
5.
5, my lord.
What 5?
My lord, Suomoto case.
WPC 5.
Yes, my lord. Limitation Suomoto order is, my lord. Suomoto petition, no, 3 of 2020, my lord. 3 of 2020, my lord. Yes, my lord. This, my lord, as your lordship has rightly held, my lord, the limitation period was to some extent, my lord, lordship would appreciate, my lord, it was at a time, my lord, when streets were, my lord, that is another judgment I just wanted to refer for my lord, own satisfaction. This is a judgment, my lord. 2015. 2015, my lord. 14 SCR 565, my lord. Paragraph 14 and 15 for the my lord, this is in relation to a selection process of a fair price stock, my lord, in which, my lord, the selection process was over. He participated in the selection process and he filed a challenge the selection process thereafter, my lord. The Honorable Apex Court held, my lord, relying on a 4-judge bench of your lordship's parent court, my lord, in the matter of Udit Narayan Singh, my lord, and that, my lord, if a person wants to challenge a selection process after the selection is over, my lord, then the person who has been selected has to be made a party, otherwise the writ will not be maintainable. My lord, by corollary, my lord, I want to draw the proposition, my lord, if it is the law that your lordship has said that the parties who have been selected will be a necessary party, then, my lord, subject to correction, my lord, then, my lord, it may be possible, my lord, even to challenge the selection after
This Poonam versus the state of UP, the apex court has held that those who have been selected, they may not have a right to hearing also.
Yes, my lord, in that perspective.
In this case. Because what can they say? The apex court has said what they have to say. If they are the beneficiary of a wrong, if we remember correctly in Poonam, this has also been laid down.
Yes, my lord, there cannot be any straitjacket formula of principle of natural justice.
Natural
that
justice,
is also
correct.
held.
Correct.
Yes, that is correct. I bow down, my lord. That is also a proposition of law that has been laid down in this judgment, as your
Poonam
lord.
versus state of UP.
Yes, my lord. So, my lord, but this also the point, my lord, that if there, my lord, that is another judgment that I was relying upon, my lord, to answer your lordship's query, my lord. My lord, Om Prakash Chopra I am not citing because lordship has already noticed the proposition of law, my lord, and has already, my lord, made your lordship's oral observation, my lord. My lord, this is on the proposition which is not be applicable to me, my lord, before publication of result, my lord. After the selection process, I participate, whether I can challenge it before publication of the result. It is to that effect. This is not applicable to me because, my lord, I have admittedly challenged it.
Which one?
My lord, the one 2015 11 SCC 493, my lord. This is a challenge can be done.
Then why are you? If it is not applicable, why are you?
Not applicable, my lord. Not applicable.
In this, which paragraph you are relying upon? Poonam versus
Poonam,
State
my
of
lord, Poonam, my lord, kindly sees paragraph 14 and 15, my lord. My lord, there is a judgment which is against me, my lord. That also I want to cite a recent Supreme Court judgment. कोई आगे जजमेंट भी बताओ.
fourteen and 15 is at page 577.
My lord. Yes, my lord, 577.
Give this back. Give it back. Unnecessarily multiplying. Same. Which one is that?
My lord, then I would like to cite a judgment, my lord, which is actually against. My lord, which is against me. That's been delivered recently by the Honorable Apex Court, my lord. Reported in 2025, SCC Online, SC 1751. My lord, this is against. And it says, my lord, when there is irregularity in a selection process, my lord, the selection process as a whole should not be interfered with, my lord. Unless there is glaring illegalities, my lord, differentiating Boishaki, my lord. Your lordship remembers, my lord, our honorable court, my lord, in the judgment of Boishaki, my lord, has set aside the entire selection process, my lord, which was upheld by the honorable Apex Court, my lord. This judgment, my lord, differentiate Boishaki and sets, my lord, the proposition that if there is irregularity and not illegality, my lord, the High Court will be circumspect in, my lord, setting aside the whole selection process, my lord.
How this will apply to your case?
That if, my lord, I have at a stage, my lord, where the selection process is over. Now, if your lordship is not with me with regard to illegality, my lord, then perhaps, my lordship will not be able to grant me prayer A and prayer B, my lord, which is setting aside of the selection process, my lord. That is where, my lord, it bars me, my lord, getting a relief as regard prayer A and prayer B, my lord.
There A and B is challenging the entire selection process. So how this will apply? That is what we are asking.
My lord, if your lordship holds that there is no illegality in the selection process, then your lordship will not interfere with the selection process, my lord. A and B will then, my lord, lordship will not touch the selection process, my lord.
Then what relief you will get?
I will not get, my lord. This is against me.
So therefore, why are you citing this?
As the officer of the court, my lord.
No, no. Not required. Give it back. You are relying on these judgments.
Yes, my lord, I am relying on those judgments, my lord.
Yes, now what do you want to say?
Grateful, my lord. Sorry.
That the first point.
Notice was served on the respondents.
Yes, my lord, all.
I do not know whether effective service has been made.
Yes, yes, we have recorded effective.
I'm not that's why I'm not, but my first point is not what the beneficiaries as per the procedures, whether legality or illegality that has been found by your lordship lord in the process. But prior to that, Lord, my humble submission, they ought to have been heard by your lordship, by the court. Otherwise, principle of natural justice will be deprived of.
On what day notice was served on them?
My lord, I have filed my affidavit of service, my lord. Different dates, my lord. On different dates. In fact, my lord, in tribunal also, my lord, only one of them chose to appear despite notice, my lord, and his affidavit in reply is in record, my lord.
এটা একটু দেখান না এফিডেভিট সার্ভিস রিলেশনশিপ।
No, which is the date on you said we have recorded that they are appeared.
Let me.
When have we recorded that they have already appeared or that there is service of notice?
No, Lordship has not recorded it, my lord. Lordship, if it is there, my lord, in the file, I handed up, my lord, the affidavit of service on the first occasion, my lord.
এটা কতবার তোমার পেজ মার্ক?
Yes, anyway, yes.
So far as the illegality, my learned friend has pointed out before your lordship, subject to correction. There is no illegality in the process because the
103.
because Lord, we have taken the point before the learned tribunal that Lord, the memo by which Lord he has given protest, that too after publication of result when he has become unsuccessful. Man, kindly note that. Kindly note that. He has waited. Though, my lord, he has given a letter, but thereafter he did not challenge the process. He was waiting for the result. But as soon as, my lord, he became unsuccessful, he has challenged the, blood the proceeding, that process. But that is my humble submission, whether at the same time, my lord, hot and cold, he can take or not. My lord, your lordship, kindly take note of it. Number two, my lord, the memo, which is relied upon, that memo was published 2019, few months back before the advertisement, but that was not taken in the process, so that he could have, his result could have otherwise. But not that is not the procedure, because memo can be published, but unless it is notified, we cannot give the weightage of that memo. That's why notification was issued by the Labor Department, Government of West Bengal, June 13, 2025, referring the memo. I'll give one copy, kindly pardon me, I'll give them the copy.
June 13?
June 13, 2025. 2025. June 13, 2025. If I may read the.
So prior to 25, there is no reservation for EWS.
This is that 2019 notification. Lordship has referred here. Dated.
So are you saying that prior to 225, there is no reservation for economically weaker section?
If your lordship kindly 100%.
No, what we are asking you as a matter of fact, why you are giving us some notification, and you say till the issuance of this notification, there is no question of application of this office memorandum. Then until 25, you are not giving a EWS reservation.
No instruction today, but notification.
What do you mean no instruction? You are appearing every day.
Yes, I'm appearing every day. But
then this is not something for which instruction is required.
Instruction is required.
How? As a lawyer, you are appearing on behalf of the state every day.
Document placed before me, I am placing before your lordship, that if 2025 the notification, by the notification that memo was given effect to. That which memo my learned friend is relying upon.
And prior to that, there is no reservation for EWS.
That notification was.
Have you given it to him?
No, I have not given, blood.
Give us, let us see.
Kindly pardon me, I am giving another copy.
No, give us 2 copies. What is this? Very,
sorry,
we don't expect this every case.
At the very first instance, what I have tendered.
You have been sitting here for so long. You have been sitting here for so long. You saw how we were dealing with him. Still, you did not bother to get another copy done.
Kindly pardon me, kindly pardon me. Kindly pardon me for this. But therefore, my lord, the notification, which is first of all, my lord, his right, whether his right is is there to challenge the process after publication of result. After publication of result. But if I may take his argument, but not admitting that he has already given a protest immediate after entering into the selection process. But he did not challenge that. He was waiting for my learned friend. My learned friend has not given an answer with your lordship has asked him pertinent question. After publication of result, that too after 3 months. But he has challenged the process. Therefore, my lord, whether your lordship will entertain at all his argument or submissions and the judgment he has relied upon, whether that is at all applicable, my lord, in his case, your lordship kindly consider that. And lord, I have also stated before your lordship that in the original application he has annexed in the petition, though my lord referred annexure D, but I have not seen any annexure with this application here.
In the application, he has not annexed.
All documents annexed. That annexure has been whitened out so that your lordship do not get distracted with this earlier page numbering and annexure number.
What is the date of the application?
My lord, the date of the application is 12/9/2019.
Not advertisement, your application.
My application 29, my lord. Oh, date of the original application. My application.
Day on which you have lodged a protest.
Yes, my lord. Protest 19/9, my lord. 2019, my lord. The first protest, my lord. Before even making application, my lord.
So where is that document? Come to page 63.
My lord, that is at page, my lord, 41.
Come to page 63.
My lord, I'm at
this is the index of the documents filed by you before the tribunal. Where is that document? Annexure which? A, B, C, D, which one?
I believe 22,
my lord,
28 to 30.
I'll just check, my lord. Annexure D, my lord, most probably because, my lord, 28, 30. I'll just check, my lord, from the averments, my lord. Yes, my lord. Annexure D, my lord.
Oh.
Page 71, my lord. Page 70.
So then 79.
19/9/2009.
Yes. I submitted my application on 29, my lord. That same.
No, 19/9.
Yes, my lord. 19/9, my lord.
That is the date given by.
Yes, my lord. 71, sir.
Very well.
What about that?
No, এখানে annexure কোথায় দেখা যায়?
Annexure.
Yes.
Page 41.
Therefore, Lord, whether your lordship will at all, Lord, entertain his petition or appeal, Lord, that knowing fully well the advertisement and the ingredients therein or criteria, but he has participated. Thereafter, Lord, according to him, he raised an objection regarding his reservation because he appeared as jail category. And lordship kindly consider after publication of result, that is my humble submission before your lordship. 3 months after the publication of result, when he became unsuccessful, he thought, yes, he has to challenge that. But interregnum period from the date of application of objection till the result or 3 months after, but he did not do anything. And Lord, if your lordship kindly, because I'm relying on judgment. Thousand 3 SCC, page 512. Similar three judges judge. Judges judge.
Which page?
But page plot 512. 512 plot the recitation.
Which paragraph you're?
Paragraph plot, if your lordship kindly see, page 30, paragraph 35.
How that is applicable?
A service rule of game cannot be changed afterwards. Minimum qualification, but applicable plot the rule procedure which was taken at the time of advertisement. This cannot be changed.
Who is saying to change the rule? How this will arise?
But my learned friend is harping upon that has got to act.
This does not apply. This has no application in the facts of the present. Irrelevant judgment. Take it back. There's not an issue arising here.
This is the notification your lordship kindly see.
Yes. See your stand. Have you seen the tribunal's order?
Yes. I've seen that.
Sure.
But I've seen that. But,
Please see which notification you have relied upon. Before the tribunal, you have relied upon a notification of 18/5/2023, saying that on that day it has come into effect. That is recorded in the tribunal's order. The tribunal's order has never been challenged by you. Before us, you are giving a notification of 25.
25 or 23.
Therefore, we asked you, did you read the order of the tribunal? See the last paragraph.
Yes, yes. I've seen that.
You have specifically stated the notification of 23 has brought this into effect. And now you are giving us a roster point determination. What is this?
18/5/2023. What is actually I'll come back with that notification.
No, now what come back? That is your stand. No, come back now. It is over.
And Lord, your lordship kindly consider this. Lord, that was not in the field. Only Lord memo number was issued, but that was not given Lord, any effect by way of notification of the government of Israel.
All right.
That's why, Lord, it was not taken into consideration.
That is your stand before the tribunal.
My Lord.
Yes.
My-
Yes, take down. Order.
Really sorry, my lord. I tender my sincere and my lord apology.
Case is over, everything is over.
Your Lordship.
But I feel really bad.
Don't learn something, that is all. Case is over, everything is over.
আমরা শুক্রবার
Item number 10.
Likhna, orders, parties have been heard. Parties have been heard. Huh.
Well, before going into the order impugned, Your Lordship, on previous occasion, Your Lordship was pleased to direct me to supply a copy of the contempt, and I am filing by way of the supplementary affidavit.
Contempt.
Copy of the contempt application, Your Lordship. Yes. Well, the two original application being OA 864 of 2016 and OA 334 of 2020 filed before the Honorable Tribunal. That was heard in extension. Thereafter, my lord, but hearing the application, the tribunal is not in session, my lord. The state administrative tribunal. The issue herein, my lord, the petitioner herein, the pay they were getting the scale number 14 has been reduced to scale number 10, and the another batch of the petitioner, that is 864, they are similar circumstance person. They got the order from this coordinate bench, mallet in WPST 104 of 2020. So on the ground of equity, mallet, I am asking for the limited protection till the culmination of the final hearing before the learned tribunal. My pay should not be reduced, mallet.
Which order is under challenge?
The order valid is at last page valid. That is the order passed in a contempt jurisdiction.
Page, order dated 5/8/25.
Order dated 5/8/25. Exactly valid. And the parent order in MA application is 161.
You want a show cause?
Yes, because without filing a show cause, without giving a show cause ballot, my pay has been reduced. The parent order in MA application, before taking any coercive action, there would be show cause. But without complying the same ballot, they drastically changed my pay scale from scale number 14 to scale number 10. And the ground of equity which I have taken, mallet, is at page 130, where the similar matter was filed before this honorable court, mallet, and the coordinate bench has protected the pay till the disposal of the original application, mallet. Kindly come to page 130, Your Lordship. that passed in WPST 104 of 2020.
No, we are only concerned with order passed in your case.
Yes, sir.
This is a
No,
contempt.
the
We can,
activity which I have taken,
whatever it is, you are in a contempt jurisdiction.
yes,
So we are not, we cannot go into this exercise. What is the order passed in your case? That is all. And that order is of 22/5/25, which you are alleging has
Yes.
not been completed.
22/5/2024. And the content and flavor of the judgment passed in MA has also been changed in a contempt jurisdiction by the learned tribunal.
You were a party to this order. You are a party to this order of 22/5/25.
Yes, sir. 22/5/2025.
Same applicant.
One of the applicant.
He was one of the applicants.
I'll come to petition number 6, Your Lordship. The petition number 5. Petition number 8A.
Yes.
I'll pray Your Lordship kindly go to page 131, sir. 130. The rights percolates for the petitioner originates from this particular order passed by the court bench.
No. We are not going to look at anything beyond this order 161. Yes. That can, this scope of this proceeding cannot be enlarged at all beyond the order of 22/5/25. Whatever 22/5/25 says, that is only what is to be implemented. Nothing less.
When Your
Nothing
Lordship will go by the parochial interpretation of that order, my lord, that has not been complied at all in my case.
Which one? 22/5/25.
Yes.
So it is your case that no show cause was served on you. That is all. And what the tribunal has done?
The tribunal, my lord, so far as the original application is concerned, my lord, that has been attained to, it was just calibrated at the last stage, but it could not pass as any order. Thereafter, before that, my lord, the tribunal tenure of the learned member was over, my lord, and the tribunal is not in session as of now, my lord. So we don't have any forum, my lord. And by the time
The
they have,
tribunal has held that it was not necessary to serve show cause on you.
yes,
That has been held
yes,
in the impugned order.
yes.
Both the orders are at variance.
But kindly see page 102 in terms of the order of the division bench passed by Justice
161 only. Page 161 only. It is for violation of the order passed at page 161. We cannot travel beyond 161. Right, wrong, indifferent, it has to be implemented.
Yes.
So he was the applicant in this MA. And the tribunal has said
directed to show
that tribunal is of the view that unless copy of the show cause notice is served to the applicant, the tribunal does not have any role and is
yes.
direct the respondent to serve copy of the show cause notice. Then why it is not being served on them?
But kindly see for a moment 105 and 105. Page 105.
We cannot travel beyond 161.
Yes. But the show cause notice issued to Obijit Ghosh, show cause notice issued to
Just show the show cause issued in favor of the applicant. Where is it?
Deepak Kumar. I find from the records that only page 103 and 105.
No, just show that show cause having the name of Arvinda Bandyopadhyay. He is the applicant.
He is not the applicant here. They are filing the separate application. My lord.
So his name is
My lord, the applicant, my lord, kindly come to the applicants are in this proceedings, my lord. I'm telling their name, my lord. Kindly go to page 158. He is petitioner number 5.
Before the tribunal.
Before the tribunal and before this.
150?
158. The
No,
name
just
is,
where is his name in the OA? Just show.
Sarath Kumar Hajra.
Where is his name in the OA? Just show from the OA.
I can show the name of Sarath Kumar Hajra, my lord, in MA application, my lord. Sarath Kumar Hajra. Kindly come to 112 at serial number 9. And also kindly peruse ballot 8A, that is Jyotindra Chakravarti.
No, here there is only one petitioner. There are 2 petitioners here.
No, petitioners are valid. All the petitioners before the tribunal in MA, they all are implemented here.
Here.
Yes.
They are all writ petitioners.
They are all writ petitioners.
Then why the first one is not there?
Because they have only executed this particular thing in a matter of the 3 persons ballot. And they are in a process to give effect to all of them.
So the other 3 persons, they have been served show cause.
No, not a single person has been received any show cause.
Anyway, those who are not before us, we need to.
And kindly see page 103. Ordinum Chakravarti has been issued show cause notice. Then 105. Obijit Ghosh has been served with a show cause notice. And then page 107. Sarath Kumar Hajra has also been served with the show cause notice.
That's not the point. You see the order which is impugned here. Where in that order it records that show cause has been issued to them?
According to this, I find from this record.
We cannot see what your stand is before the tribunal. You say that SCDPOs were not show cause. This service is not necessary.
Yes.
Not required.
Respondent, a point raises whether respondent authority could
If not, it's
5/8/2025. This at the last page. Mr. Rai learned counsel.
The tribunal was under the wrong impression. Such suppose notice was issued to the applicant who are functioning as the assistant child development project officer under CDPO. That CDPO not show cause. Rather, respective CDPO were held responsible for ask for granting scale number 40 to the applicant. Therefore, in this case, standing copies of the so-called the applicant were
Not necessary. How it can be in a contempt proceeding? This cannot be. In a contempt proceeding, how the tribunal has accepted? The tribunal agrees and accepts the remarks. How it can? This is not an appellate forum. Yes, third learned advocate for the You are trying to show some order. We want to see that order. Then we'll.
In that case, pilot, I'm praying your lordship because I'm praying for next week, pilot, because
Yeah,
that
not today means it will come on Friday.
Friday, pilot.
Yes.
Item
No order in that case. There will be no order in that, just not today.
So Friday. Right.
Item 2, my lord, is specially fixed, my lord.
Well, it was fixed.
Item number 1.
Yes.
Oh, 1.
You are making a mention.
My lord, I am appellant and petitioner number 1 of the instant case. My lord, on last Monday, I appeared before your lordship for the order for listing the case.
For
listing the case, I appeared before your lordship, taking my disease cancer. Your lordship has been kind enough and kindly list order for listing today. Now I begging for permission to place my arguments.
just who is you are for the other side?
I'm for the respondent, my lord, led by Mr. HON'BLE.
What is the issue?
The pensionary issue, my lord. No,
Prayed for the pension, my lord. The trial court dismissed the petition on the ground that they have not given the option in time. For such reason, only the person who are given option take the pensionary benefit, but
Where is the red court order? You are appearing for him. He is represented by a lawyer.
the advocate was there.
So how can he do both? He is arguing on his own and you are.
He has obtained no objection.
So now he is appearing in person.
well, I am from hearing problem. For that, I requested him to kindly help me.
You think we can complete today? We hardly have 15 minutes today.
My lord, I shall try my best. 15 minutes.
Because there is we have to
Next day
rise at.
kindly- Next day, kindly order for next day.
Yes, same day it will be at the same time.
Same time.
Tell him.
Same time.
একই জায়গায় থাকবে দুটো সময়।
হ্যাঁ call.
Due to
Next শুক্রবার মিছিল, my lord.
any problem?
Sir, no. That's any time I may die. Then there will be no
Friday.
to forward the
Friday.
matter.
The
Item number 2.
nothing effective can be done. See, there was another bench. His lordship was sitting in that bench, and now we have assembled late. And as you know,
Yes. My lord, any date, my lord? Next Thursday is okay, but 8th of December.
any day you agree it can be fixed.
Yes, my lord. My lord, whenever,
Give an agreed date.
my lord, your lordship's keeping it at 2 p.m.
Yes.
Next week ta ki? Next week আপনার 27th. Is that okay? Yeah. 2 p.m. সকালে বিল্ড 27 ঠিক আছে না 8 নয় next week to first second আরে just give the Thursday no 4th. How's the 4th? 4th is today. Oh, that's okay. 4th, my lord, 4th of December if it comes.
Agreed. All right. I think 4th is before 18th.
Yes.
He said 4th. So he's, oh, you want after 10th? Oh,
My lord, I'll be addressing, my lord, I'm the appellant.
so he will start on 4th, we can see.
Perhaps respond after that. Yes.
Same order.
Item number 3. Item number 3, my lord, we have filed CAN 30. This application for publication of the or getting a report of the expert committee, my lord. The matter, my lord, today was taken up by the single judge.
Today.
And the report has been taken by the single judge. The matter will be coming up on Monday.
So now nothing survives.
Prayer before the division bench, my lord, only to the report which they have, my lord, filed, my lord,
If
just
it has been filed today, then what remains? There's no use of.
But reason, my lord, why we want this report, my lord? Because, my lord, we are
Why here? That is the point. If it has already been filed there, then why? What are we? We will not
already-
supervise the single judge.
we have not got a copy.
So should we direct the single judge? That,
No.
What do you want?
The board may board may
Making a
supply.
pointless prayer. When you know it has been filed there, you go and take it there. Who is stopping you? And why do you think you will not get it?
No, I will get it.
Then what are we to direct? See, we don't know anything. We have not even opened the brief. All we know is that some CAN has been filed for some report which was to be filed before the Honorable Single Judge. That report has already been filed today. So therefore, that CAN, what is that CAN number?
CAN 30, my lord. My CAN.
What is the main appeal?
Main appeal, my appeal has no.
Oh, yes.
No, my lord, appeal has been filed by the board
So
challenging
then
the.
CAN, there's nothing survives.
My
in
lord,
the CAN.
one thing, my lord, appeal has been filed by the.
You want the CAN to remain pending only?
No, I just want to say what has
Yes.
happened. Appeal has been filed by the board challenging the order of single judge.
This appeal.
This appeal, which has been disposed of.
Disposed of already.
Because
So
the expert committee which has been appointed
for
by
whatever reason it
that
was
was changed.
disposed of.
And
There is no
subsequently-
review of that order.
No, they have filed again the modification application and the committee was modified. There were
That we have seen. Last day we have
Yes,
seen.
yes.
The CAN is now, it is not surviving. If it is already filed, you that day also, if I remember correctly, Mr. Bhattacharya was appearing.
Yes.
He said because it is not filed. So now it is filed. Then what remains?
The envelope is opened by the honorable single bench matter and matter left on Monday.
Monday.
So it might be they will in the meantime.
See, this CAN is infructuous. If there is any occasion, then always what you have done, you can again do.
Why can survive not because it's separate application. The prayers are also separate. One single prayer is different. I have paid for modification of the order. That is why my can survive. If without time keeps the my can pending at the same point of time, let the single judge to the full and the court.
Very well, then we can't do anything today. We are just not today. We'll see it on the next day. Yes. Very well, not today, all these matters. No orders.
Right now, there is no the utility of the pending of the CAN.
Captain, anything, Captain. Captain, anything.
Your Lordship,
Not today, just not today.
applies no order. Grateful.
Yes, already called.
Offline.